still coming on. My name's Amy O'Hara. I'm a partner here at Littman Krooks. Today I'm talking about, you know, I want it to be a roundtable, we can't really do a roundtable discussion with the number of participants that we have, but the idea of, for yourself, what you could do to plan for when you eventually pass away, as well as if you're ever in a role as a fiduciary, as an executor, trustee, and what you can do and what things that you need to know. And please, I think my office has pretty much muted everybody because of, we don't get any, otherwise we get a lot of background noise and it's hard for people to hear. So please, I welcome you to use the chat function, and I will look at it from time to time. I'm not going to be able to look at it throughout this, but I'll be able to look at it from time to time, and we'll get through the questions by the end. Some of the stuff you may already know, so I may be repeating myself, especially if you've met with me, but some of it may be new, or you may pick up things here and there. So first I'm going to talk about, like, for you, like what, you know, what planning that you could do. I mean, I think in this COVID era, it's all put different things in perspective. And I'm sure every single one of us knows individuals who became ill or even lost their lives to this horrendous virus. So it makes us step back and think about what do we have in place? What planning do we still need to do? Have I let my family know everything that I need to know in terms of organizing my affairs? And so, you know, we used to have this nice little book, you know, what my family should know. It's pretty much out of print now, but if you've done your estate planning with us, you know, is when we send you all your documents, we have kind of this in there in where you could fill in. It looks different, but it's, you know, and it has different things that your family should know. And we have it where we send it in Word to people as well, where you could list your important, like, social security number, where your papers are, your marriage papers, birth certificates, insurance papers, cemetery deeds, all of these important documents. And it's also one thing to just write it somewhere, but it's important to let your loved ones know where in your home these documents are. Word of caution, and I may repeat this again, is be careful of safe deposit boxes and putting items in safe deposit boxes, because oftentimes the box will be locked at your death if the bank finds out. 2 or 3 times recently, actually last year, it happened to me 3 different times with clients where their spouse died, and not picking on any banks, but Chase and Citibank both locked the safe deposit box, and the surviving spouse could not access it even though they were joint on it. And we had to wait to go through a probate proceeding to gain access. So be careful about keeping original documents. And there's no ideal place, because that would be the ideal place, except for the idea that it could get locked at your death. You know, because I don't know how fireproof boxes are. I have one in my house, and I have my important papers in it. Fortunately, I've not been through a fire to see how it fares, but I do, you know, and that's what I do as well. You know, so, but let your family know where in your home these documents are located, or if they are in a safe deposit box, maybe eventually you add a child or other loved one who, not necessarily just your spouse if you're married, or your partner, but maybe that next generation or whoever you have as your fiduciary as a joint owner on that box, for the hope that it won't be locked at your death. Automobile titles, thinking about where those are. Information on all your financial accounts, bank accounts, retirement accounts, life insurance, usernames and passwords. Yes, we have made certain strides with legislation, with allowing fiduciaries the ability to access certain digital assets, but it still has a ways to go, and there's a lot of privacy issues. So the best thing that you could do on any documents or excuse me, accounts that you want your fiduciary or your family members to have access to, write down the username and password. That's just the easiest foolproof way. You know, it's like my mom keeps this little book that says usernames and passwords, and she got it like from a Lillian Vernon type place, and she writes it in pencil, and she's actually very good with updating it, because the thing is you have to update it because you may forget, you know, you may change a password or something may change, and just update it. And again, you don't have to give that to your family member or your fiduciary now, but let them know where to find it in your home. Okay. You know, it's amazing how much now we have in the cloud: photos, videos, other family memorabilia, genealogy charts, and not only just limited to assets, you know, like actual assets, but there's a lot of more personal items that you want to pass on. Is, you know, the best thing you could do is just give your usernames and passwords or write them down somewhere. What are your liabilities? What you know, what liabilities do you have? What debts do you owe? Where are your mortgage papers? If there's credit card debt, you have an auto lease, you know, write that down or keep information or paperwork on that. And then your personal wishes regarding your burial and even your end of life, you know, with regard to your healthcare proxy, what your wishes are, so that they could be honored and that you have the appropriate people in place to be able to effectuate those decisions. Today's webinar or Lunch and Learn is really not focused on advanced directives. And in fact, I think we may be repeating one that I did back in January on September 8th. Just keep out for, so that we'll talk about advanced directives on that. It's gonna just be a repeat. So just keep your eye out for emails. But so today I'm really not focusing on any type of power of attorney, healthcare proxy, or anything like that. But also, you know, the most recent signed document. So let's say you changed your will. 10 years ago, you created a will, and then 10 years later, you updated your will. Get rid of the old will, have a new will, or have the new power of attorney or healthcare proxy, whatever those most recent legal documents are. Otherwise, it could cause confusion if there's an emergency and there's all these different papers and your family or your fiduciary doesn't know, you know, or it causes them confused. I mean, you would think you would look at the most recent date, but there's still a lot of confusion on that. I will also say what I'm talking about today is generic, except it is there are some state-specific rules, especially when I get into talking about administration. So I'm really focused on New York. And if you have been through this process for a parent or other family member in a different state, and it varies a bit from what I'm talking about today, just know that we have very state-specific rules when it comes to administration of estates, even across the border in New Jersey and Connecticut. And even here in New York, because through our probate courts, it's at the county level, and each county, each surrogate's court, what we refer to as a surrogate's court, has their own rules. And so even, you know, things that we do in Westchester will be different than we do in Kings County or New York County and Manhattan, because each judge does things a little bit different. So just keep that in mind in play as well. Another advice that I would have is have your team in place, your attorney, accountant, financial advisor. Make sure they know each other and they have permission to communicate with each other. It's good, you know, even if we tuck it away, like people will let me know who their accountant is or their financial advisor. I don't necessarily need to contact them right now if I'm doing somebody's, you know, updating their estate plan or doing their estate plan for their first time, but it's good to know. Sometimes we'll just exchange a quick email. Yes, I'm Amy. Yes, I'm Pete, you know, here, you know, just so that we have that in case it's needed in the future. The other item before I move on to some of the administration aspects of this is at some point have a family meeting or document, you know, why you made certain decisions in a letter. It's not necessarily would have standing if there was any contest to it in court, but at least it sets forth to your immediate family what your wishes are, why you made certain decisions, who you put into place. Some people are not comfortable having that meeting face to face, or or over the phone, and they'd rather write it in. Now, that's always preferred from my perspective, but then the next thing would be, if they're not comfortable, is talk about it in a letter. Write out why you made certain decisions and why you designated the people that you designated. And especially if every once in a while in our traditional family, where we may have a spouse or partner and children, and maybe you didn't treat the children equally in the distribution, that maybe you left one child 70% of your estate and the other child 30%. Explain that. Explain your reasoning behind that. Maybe the child that you left more assets to, had more of your estate, may have a disability and may have extra needs and doesn't have the income that the other child has, or vice versa. Maybe you left less to that child because a lot of what's being provided for, they already have, and they don't have a lot of extra needs. But set forth your wishes and or why you made certain decisions, or have that family meeting, and let the individuals know that you designated them. It's people don't often tell whether it's a sibling or they're a child or a friend if they don't have any children, or they're married, or maybe they weren't appropriate to choose them, but let the individuals know who you're designating, that you're designating them as executor, trustee. I know I wasn't talking about it, but power of attorney, healthcare proxy. So one, they're not surprised that you designated them. Two, because you want to make sure that they actually are up for the job, because it's, as we're going to get into in a bit, it's a big job to be able to fulfill these roles and the fiduciary responsibilities that go with it. And you want to make sure that they consent, because if you find yourself in a situation where you've designated them and you've passed on, and now they learn that they're appointed and they don't want to serve, you lost control over who is appointed, because then the court's going to appoint somebody. And it may be somebody that you have never wanted to act on your behalf. And so that's another thing, to also not only have one primary, but at least have one successor, and sometimes two successors. So I'm going to pause here and just see if, before I move on, to see what questions we are at right now. Okay, when I mentioned before about the safe deposit box and how, I don't find this routinely, but I was surprised. I had it 3 times last year where we had these safe deposit box that were locked. And the question is, does that apply to like joint accounts, like bank accounts? The answer is no. It should never apply to joint bank accounts, because by operation of law, whoever that joint owner is, the account is supposed to pass automatically to, or become that person's sole account upon your death. So whether you have it joint with a spouse or a child, that account or that asset automatically becomes theirs. When turn over letter with your reasons for decisions in formal documents. I don't quite, if something with the letter with your reasons for decisions, and can somebody just retype, whoever wrote that, just retype it a little bit more so I understand what you're asking, so I could properly answer it. Okay, and I'll come back in a bit. So the Chase locked box that was physically in the bank, yes, that was Chase with 2 different clients last year, and it was spouses we had living, and Chase locked the safe deposit box. It was, and people had to spend easily a couple $1,000s in legal fees to be able to access the account. One of them, it was a client, was a deceased attorney, and he had some wills of some of his clients in his safe deposit box. So we had to do an emergency proceeding, because of course some of those people had passed away and their family members wanted to get access. And so it was, but his wife was on the account as well, and it was locked. So we were able to get access to it, but it took time. All right, I'm going to move on now to administration and the administration process. What happens if you die with the will? What happens if you die without a will? Or that you are on this call are designated in this fiduciary capacity as executor, administrator, trustee of maybe a revocable or irrevocable trust, and walk through that process a bit. So when we die, we take a snapshot of what our assets are. And this is often confusing for people to grasp, that if somebody creates a will and their will says, I leave everything to my spouse and then equally to my children, or maybe I leave everything, to my children, or I leave everything to my nieces and nephews. But then you have certain accounts, and this comes back to the joint account question that somebody just asked. But if you have any accounts that are jointly owned with an individual, that will pass outside of your will, what we refer to as a non-probate asset. And that particular asset will pass to whoever is on that account. Similarly, with a beneficiary, that if you have an account that's in trust for somebody, has a designated beneficiary, which oftentimes you'll find with retirement accounts or life insurance, that those assets will pass in whatever percentages you listed on that beneficiary designation to those named beneficiaries, regardless of what your will says. Sometimes you may have assets in an irrevocable trust. And I'm going to get to a revocable trust in a minute, but same thing with the revocable trust. Whatever assets are owned by that irrevocable trust or the revocable trust, those assets will pass pursuant to the terms of that trust, not what your will says. Okay. So keep that in mind when you're thinking about your estate plan and how assets are distributed among the individuals or charities that you want to inherit. So with regard to, so that brings me back to the will. When somebody dies in New York State, they either die testate or intestate. Testate means they died with a will. Intestate means that they died without a will. And just to throw a couple other legal concepts at you, I mentioned before non-probate versus probate assets. So probate assets are assets that are passed under your will, or even if you died without a will pass pursuant to the New York State administration process. And non-probate assets are those ones that I just gave examples on before: joint accounts, accounts that have named beneficiaries, or maybe already in trust. And so when we look at all that, then we also have what's called gross estate. So when we're looking to see if there's any estate taxes owed, whether at a New York level or the federal level, we look at your entire, any type of incidence of ownership that you have in all these different types of non-probate assets, probate assets. We look at everything to determine whether your estate has the obligation to file an estate tax, and if it does, what the estate tax will be that's owed. So back to the probate process, somebody dies with a will. Another common misunderstanding, or people just not aware of rules in New York, that if you die with a will, and let's say you disinherit your children, or you want to leave everything to charity, and maybe you're not married and never were married and don't have children, and maybe you have nieces and nephews, and you left everything to charity. What New York State law says is, whoever, if you died without a will, if you died intestate, those individuals, what we refer to as distributees, your next of kin, are entitled to be noticed in the probate process. So let's say you disinherited a child, or you left, like I said, you left everything to charity, but if you died without a will, that one child was entitled to be noticed, or those nieces and nephews were entitled to be noticed. They are entitled to get notice and sign, and they consent to the probate. And if they don't consent to the probate through signing what's called a waiver and consent, Then under that scenario, we have a court date where they have the right to appear at a court date to contest or to say, what's going on here? I just, I thought I was left assets under the will. So sometimes, and I'm going to get to the revocable trust segment in a minute, but sometimes people don't want to give those family members that ability to have that right or that ability to contest or have knowledge of this, not that they would necessarily contest, but just to even have knowledge of what decisions you made and why. And so they want more privacy, and that would be a reason for a revocable trust or revocable trust, which I'll talk about in a little bit. But so those individuals are entitled to notice. Also, if you disinherit your spouse or you leave less than your spouse, in New York State, under New York State laws, you could disinherit anybody, including your children, except your spouse. Now, you can disinherit your spouse and you could not leave assets to your spouse. However, if there is no prenuptial agreement or there is no, where your spouse waived his or her right to elect against your estate, they have a right to file a claim against your estate and receive 1/3. Okay, children don't have that right, but spouses do. Now, oftentimes, if somebody's disinheriting their spouse, the spouse knows about it. And they've already consented, or maybe they're incapacitated and we're doing some elder law planning and there's a specific reason why we're disinheriting that spouse. But just know that they have that right. The other part is with the will is we have to submit the original will to the court. So you cannot lose your original will. I joke that you could lose copies of the original power of attorney or healthcare proxy, and oftentimes the copy will suffice. But the one document you could never lose is your original will, because we have New York case law, cases that say if your will is lost, it's presumed revoked. In my history here, in practicing in New York since 2002, I have been able to probate a copy of a will one time, and that's because we could literally prove that the will burned down in the house, an apartment. It was in Stuytown in Manhattan, and there was an apartment fire and the will burned. And we had to get affidavits from the attorney who drafted it, the fire department, and we had to prove, but the court, and nobody was contesting this will, thankfully, and there was a special needs trust in that will for one child. So it was really in our interest to probate the will, because we did not want to frustrate the intent of protecting the child's interest who needed to rely on government benefits. So word on the, otherwise, just don't lose your original will. Keep it in a secure location. Okay. I had one thing, so I forgot about that I want to come back to in the probate that I'm not remembering right now because I didn't write it down. So I may jump back in a minute, because I'm going to move to the administration process, because talk about probate, that's dying with the will, and then I'm going to talk about administration, and then it's going to kind of come together because a lot of things overlapped. With an administration, actually no, hold on, this is any. Let me just write one thing here that I want to mention later. Okay, administration, die intestate. You die without a will. So if you die without a will and you have assets that need to go through probate, New York state law determines who inherits them. And what New York state law says, if you're married and have children, and you have assets that are not completely joint with your spouse, the first $50,000 will pass to your surviving spouse, and then your estate is going to be split 50% to your children and 50% to your spouse. And that's 50% to your children, regardless of whether they're a newborn, 2 years old, 18 years old, have developmental disabilities, maybe on government benefits. They inherit that outright. And if they happen to be under 18 or under a legal disability, then their share is actually going to be held in joint control with the court, which we never want to be held joint control with the court. And sorry if there's any court administrators on here, but it's a pain in the rear because you have to, first of all, have a guardian of the property appointed. And then we also have to seek permission. You have to do annual accountings. You have to seek permission whenever you want to spend money from that account. Often, even if there's a parent at home and they may need to rely on that money, but the court's going to say, well, mom, if it's the dad that died or the other spouse, I should say, you know, mom, well, how are you supporting the child? So they're not going to want to see all these assets because they're going to see the guardianship funds be preserved for when the children become adults. So oftentimes, that people will come to us from time to time when a younger family, you know, somebody in their 40s or 50s, you know, passed away, and they may have purchased the house before they got married and they never added their spouse as a joint owner, and maybe they intentionally kept assets in their name and they never added their spouse as a joint owner, and they're in for, you know, a surprise when I have to tell them that, and it's very frustrating and it's costly. It's oftentimes more costly to deal with these types of issues than actually hiring a lawyer to do the right job and getting a will done. You're not paying for it during your lifetime, but your estate's paying for it. You also don't get to choose who is your fiduciary, who's going to administer your estate, or if you have minor children and there's no parent, who's going to be the legal guardian of those children. Now, I stopped at just what happens if you died without a will, and I mentioned how it's split between your spouse and your children. Let me take it a few steps further in case you don't have a spouse and you don't have children. But if you do have children and you have a predeceased child, it will pass to your grandchild. If you're not married and never had any children and you don't have any issue from your children, then the law says your estate passes to your parents if they're living. Now, that may not always be ideal, because what if your parents are elderly and they're trying to protect their assets and they don't want more money or assets in their name? And then if they're not living, then your brothers and sisters, nieces and nephews, and then it goes down to first cousins. Now, that's not what everybody wants. They don't want that traditional split, and especially if that 50-50 split between the spouse and children. You don't get to choose who your fiduciary is. You don't get to choose who's guardian of your children. Oftentimes, or actually almost every single time, when we have to go through the administration process, whoever is appointed, the administrator, has to be bonded. So they have to pay this insurance, which costs a couple $1,000s, and which the estate would ultimately pay for, but it's just additional fees. Back to the probate process, because I remember what I wanted to mention before, is think about second marriages or third marriages or your non-traditional marriages, that if your spouse leaves assets, if you leave assets to your the surviving spouse who's not the parent of your children, that those assets, and you don't leave it in trust for your surviving spouse, those assets become theirs. And their will, they could do whatever they want. There's no contract, there's no requirement that they have to leave those assets to your children. So a very important part of when you're thinking about your will, how your estate unfolds, again, in your, not your, basic cookie cutter, family. We always go through all of that when we're working on somebody's estate plan. Now I'm going to kind of lump it together, unless if I'll let you know if there's something that's specific to administration, again, dying without a will versus testate, dying with a will. A lot of these next things that I'm going to talk about will overlap or one and the same. Be prepared that an estate administration process lasts at least a year. Prior to COVID, our courts were backed up. It would take about 2 to 3 months for when somebody died, but whoever the administrator or executor is, to be appointed by the court. Since COVID, we're hitting even more roadblocks with delays because the courts are backlogged, because they were, in that sense, except for emergency matters, they were closed for 2 to 3 months, and they're just getting back up running, and we still don't even have face-to-face court appearances. We're doing everything remotely. So expect delays, but even if there were no delays, without delays, expect the process to last about a year from when you're appointed. And the other thing is that when somebody dies, you have to wait until the will's probated or you become administrator before you can actually get access to those accounts or those assets. So you're going to be limited in paying bills, paying any debts, paying the mortgage, paying homeowners insurance, although I would figure out a way to keep that homeowners insurance up to date, even if you have to come out of pocket for it, and then you get reimbursed, because it's always difficult to get insurance in an estate. So it's going to take a while. If we have a situation where one of the beneficiaries under the will is disabled, and they have a legal guardian appointed for them, then the court will appoint what's called a guardian ad litem. They will appoint an attorney to represent that child with a disability's interest in the estate proceeding. And that will delay, and the estate will have to pay that guardian ad litem, and that will delay the proceeding a bit longer as well, because they have to do the investigation on behalf of that child with a disability. So that could be another check on sometimes why I'm recommending now, so more than I did ever before, the use of revocable trust to try to avoid this probate in this whole process. So it takes you a couple months, I'd say 2 to 4 months now to get appointed, to have your official ability to act. In New York State, a couple rules. New York State requires the assets to remain in New York, unless it happens to be real estate or real property outside of New York. We have a law where you should not, and you really should not, make distributions for a period of 7 months after you've been appointed. What happens is if you make distributions before that 7-month period and there are valid creditors that came, whether it's unpaid medical bill or credit card bill or mortgage or whatever it is, it's a valid debt that's owed to a company, and you didn't satisfy that debt, even if you didn't know about it, and you make distributions before the 7 months, you could be held personally liable and be surcharged. So if there's debts that you know about, of course you have to pay those off, but this gives that 7-month period to, for creditors that you may not be aware of to file a claim against the estate, say, hey, I'm owed money here, so please pay me. If there's no money left, then, and you can't get that money back from the beneficiaries, you would be personally held liable. So you want to wrap up taxes. If there are estate taxes owed, they are due within 9 months of the date of death. And the tax return, because sometimes we have to go an extension, is due 9 months after date of death, or you could get a 6-month, automatic 6-month extension, but the taxes still have to be paid. And so we have to figure out how to get access to assets to pay the estate taxes. New York right now, we have a New York State exclusion amount of $5,850,000, meaning your estate does not have to pay an estate tax until all of your assets, again, remember, not just what passes under your will, but everything exceeds that number, with the exception of certain irrevocable trusts. Sometimes we do, as part of a estate plan, irrevocable trusts and move assets to that type of trust so that it's not includable in your estate. So oftentimes those assets, if that's the intention of it, won't apply to that $5.8 million number. But once in New York, once you're $1 over, and we say the cliff, you're going to pay tax from $1. And it's a graduated schedule, but it's pretty steep at a 16% tax. So it maxes out at 16% tax rate. Federal, we're dealing with a little bit more than, it's $11,580,000 exemption. And federal works different in that you only pay an estate tax of any assets that are over that amount. And that's a combined estate and gift tax. So if you gave away $2 million during your lifetime, then it's at your death, if your estate exceeds $9,580,000, then you will pay an estate tax. It's taxed at a 40% rate. I will say, and this law is set to sunset January 1st, 2026. So December 31st, 2025. It's set to go back to the old law. which will end up, depending on inflation, it'll be between $5 and $6 million. That's per individual. So if you're married, you could double it, but we have to do some planning to double it. And I do expect it to go back because we're all paying for these, these COVIDs and these relief bills, much needed, but the money has to come from somewhere. And so I expect, that we're not going to stay at the $11 million estate tax amount. It's going to go back to 5 to 6 million at some point. It may be lower. I don't know. I don't know if it would go lower than that, but I'd be shocked if it didn't go back to somewhere between 5 and 6 million. Fiduciaries. So executor, trustee. I'm not going to really talk about guardian right now of minor children or children with disabilities, but when you die, there's different. So we look at executor if you have a will, they administer your estate through your will. If you die without a will, that individual is referred to as administrator. And if we're using a revocable trust, or if your will sets up certain trusts, that is referred to as a trustee. These individuals, or sometimes trust companies, are referred to as fiduciaries, and they owe a fiduciary obligation to your estate and to the beneficiaries that they serve, that are benefiting from your estate or trust. I'm going to come to a trustee in a little bit. I'm just going to focus on executor and administrator right at the moment. And actually, and trustees. So, because in any of these roles, you could designate one individual. Not administrator, you're not designating anybody because you died without a will. But with a will or a revocable trust, you could designate one or two, sometimes more than two. I don't always recommend that because it becomes difficult. Sometimes you could have an individual and a professional or a corporate trustee. Other times, you could have two individuals, or they could be two family members. They could be two siblings or two nieces and nephews. The idea, though, is that, and sometimes people want the two because they want that checks and balances, or is more in terms of the check and balances, but then other times they designate it because they want the ability that they could share in the roles, and it's one trustee or executor does certain things, and the other one does other things. But know that when you serve in this fiduciary role, or when you designate somebody in this fiduciary role, they have to act together, and you really want them to get along, because if they don't, they're both going to have their separate lawyers, and who's going to pay the legal fees is your estate. And there's going to be court proceedings, and there's going to be pleadings and accountings, and it's going to get very, very costly. So give careful thought when you're designating more than one fiduciary. When you're designating a fiduciary, executor, or trustee, you want somebody that not only has common sense, but that will get the work done and not sit on their butt and not do anything, but is fiscally responsible, will meet the needs of the beneficiaries, will collect the assets, pay off the debts, and try to wrap up the estate as quickly as possible. Because I mentioned a year, and you're probably sitting on the other end of this call or the computer screen like, wow, a year is a long time. I could tell you, in dealing with estate and trust administration, a year is not a long time, but 5 years is a long time. And I have been involved in estates where they exceed 2 years, 2 to 5 years, and we're in it for the long haul, because either the executor or the trustee is not doing their job, they're sitting on their butt, or they don't get along. And then there's issues that unfold, and sometimes there's court proceedings, and it just gets ugly at that point. So you want to make sure that you choose individuals or corporate trustees that are going to get the job done and do right by you and your estate and your beneficiaries. And it's worth to revisit that everything that I'm talking about today. If you haven't picked up your will in the last 5 years, and especially 10 years, pull it out, look at it, make sure it meets your wishes and your intentions, and you're designating individuals that you want and know will act. If you're designating similar generation and you're older, you're going to want to think about the next generation. Who's a generation removed from you that can act? Not everybody has family members that are able to act. And then we look at corporate trustees or corporate executors. But you know, oftentimes people are going to have a certain size or certain net worth in order to have a corporate trustee involved. And not everybody does. You know, we deal with many families that just don't have that ability to have the means to be for their estate or their trust to hire a corporate trustee. So, you know, it's just, that's something that we would walk through and talk about when we're doing your plan. How am I doing on time here? I'm going to have to wrap up soon. Let me get to your beneficiaries. Your beneficiaries have a right to know what's going on in the estate. They have a right to demand an accounting if you're not being forthcoming in you know, the administration, or what the assets are, what they're entitled to. Oftentimes beneficiaries, depending on who they are and if they're a family member, they, you know, or actually if they're named in the will, they have a right to see the will. They have the right to see the trust. So you owe, if you're acting in these roles, you owe a fiduciary obligation to these beneficiaries. And they can hold you accountable if you're not going to do right by them, or the fiduciary is not doing right by them. I just wanted to touch one point on a revocable trust, and then I'm going to get to a bunch of your questions here. Revocable trusts, I could say our firm has been recommending them more often in the last 5 years, and especially in the last year, given COVID and how everything has been at a standstill at the court. The idea behind revocable trust, and we'll be having another webinar. I don't know if I'll be doing it or one of my colleagues will be talking about it, but the idea with avoiding probate, to avoid to go through the court. Now, sometimes the estate still takes a year to wrap up, but the idea is that we, you know, for privacy, maybe you don't want certain family members to know about your will or be entitled to notice. Oftentimes we find revocable trust, again, not the purpose of today's call, but helps with if you suffer any type of incapacity, and it helps designating whoever you have as trustee to manage your affairs. It does not do Medicaid planning, but in terms of helping certain affairs. In terms of the privacy in the estate, even sometimes, you know, the idea though is that you want to make sure, if your goal is to avoid probate, and I always put quotes around that because it's very hard to not forget, you know, sometimes people forget about an asset or a savings bonds that they have in their safe deposit box and they never move that to the trust. Sometimes we still have to go through probate. I'm dealing with a family now who, you know, went through everything, funded the trust. The aunt, we retitled her co-op apartment, her upstate property, all her bank accounts, and now, lo and behold, there's a $60,000 account that she opened recently, unbeknownst to anybody, and had it in her name. And there's $60,000, which is over the threshold in New York for a small estate proceeding, which is a simplified proceeding. And her revocable trust names about 40 people and charities. So we have to do a big involved process. And it's, again, we have to notice extended family of this. So it's involved. So revocable trust, the idea is that it's meaningless if you just come to me and say, I want to create a revocable trust, and if you don't fund it. The idea is that you need to fund it to avoid that probate and to revisit it every once in a while. I'm going to get to your questions. Let me go. I have a lot here, so bear with me. I'm trying to go in order. When does the letter of reason get to family? Oh, how does the letter get to the family? So this was the question that the person was asking before. So if you write a letter, how does your family get it? You need to let them know, or let some family member know that, listen, I wrote this letter. It's my wish that it not be open until I'm ill or if I pass away, and let them know where in your house it is. If it's stuck on your computer and they don't have the password to your computer, that's not going to help. You could give a copy to your attorney to hold on to as well. I do that for clients many times, where I'll hold on to letters in their file, in their digital file. So yes, you want to let them know. With original wills, our firm does hold on to original wills. We don't hold on starting about 2 or 3 years ago, we don't hold on to original wills of new clients that have signed, except if they enroll in a certain, what's called a peace of mind plan. But on our older wills, we hold on to for the time being. We just have many, many wills, and you know, sometimes they've been updated and we don't know. So yes, if you have your will with our firm, then we have it in our safe. Our New York State and federal estate taxes based upon probate and non-probate assets, or only probate assets. It's based upon probate and non-probate assets, based upon anything that you potentially own. All incidents of ownership, so joint accounts, accounts in trust, retirement accounts, life insurance that's not in an irrevocable trust. You may have $1 million term life insurance policy and you'd have no enjoyment of it during your lifetime, but that $1 million still counts towards those numbers that I gave before, if it's not an irrevocable trust. Could I please clarify what I said regarding spouse disinherited versus intestate? Okay, the rules are different. If you die with a will and you don't leave assets to your spouse, versus if you die intestate and what your spouse is entitled to. And again, this is New York State specific. If you're not in New York State, it could be a completely, and it likely is a completely different rule. If you die in New York, testate with a will, and you don't leave anything to your spouse, if they didn't agree, if they didn't sign a prenuptial agreement or agree to waive the right to elect, sorry, there's a little ant here, against your estate, then they're entitled to elect 1/3 of your assets. And that could be 1/3 of assets going through the will and outside of your will. It could be that overall. It depends. There's a lot of rules I'm not getting into now, but 1/3 of your estate. If you died intestate without a will, your spouse is entitled to the first $50,000 and then 1/2 of the balance. Of that's probate. So that one could be a little bit different because you may have non-probate assets. It gets complicated, I know, and it's different for the different rules. Is a special needs trust part of my estate? You have to make sure your will is updated to make sure that it's included. And if you want to call me afterwards quickly, like, and if we did it, I apologize because I just don't know offhand. We'll talk. But yeah, so the special needs trust. Let's just pause there for 1 minute because that's a very good comment. Especially if we die intestate, you want to make sure that if you have a child with a disability, that the child that you have, and they need to rely on government benefits, and they're not able to manage their own assets, because oftentimes we'll have children with disabilities that can, and don't need to rely on government benefits. We want to make sure that we have the appropriate special needs trust established, whether it's testamentary, meaning it's created under your will and it doesn't get established until your death, or inter vivos, it's created now during your lifetime. And then, do I pay estate tax on it if my estate exceeds the, yes. It depends on how the special needs trust is set up. So sometimes if we're creating special needs trust, that we're doing it for your children, for your child, and it's revocable to you, the special, and so you put money in it during your lifetime, yes, it can be includable in your estate for tax purposes. So it all depends, and it's not one answer because we do things differently for different families and for particular to their needs. So there's not one specific answer for that because it depends on your particular situation, on how that trust is structured, because some special needs trusts or supplemental needs trusts are not includable in your estate for tax purposes. It depends how it was set up. Is it a good idea to pay for your own burial while you're alive? I would actually say yes. And the reason why is because it's one less, first of all, you get to choose what you want. You get to choose, you know, and you set forth if you want a really big you know, funeral and burial or services or flowers and or if you want it simple. And if you've prepaid for it, all that decision making is already taken care of. And your loved ones don't have to worry about what you wanted or where to come up with the funds, because sometimes your estate may be tied up in probate for a few months and the family member will have to come out of pocket to prepay for the funeral, to actually not prepay, but pay for the funeral if you haven't prepaid for it. So it's always, I typically recommend it for my clients, not usually when they're younger, but when they're older and they're starting to think about this, I think it is a good idea. You get control over what you want. If you have all the legal documents you mentioned, will, beneficiary, so if you have a will, does it still take so long? Yes. Probate takes a year, I would say minimum. From the moment that you pass away, if you have to go through probate, even though you did everything perfectly, it just takes time to work its way through the courts. For the beneficiaries to sign the paperwork, for the lawyer to be hired, to draw up the paperwork. I say in our office, it usually takes about 2 weeks or so for us to prepare all the paperwork, but then it's longer for the beneficiaries to sign off on the various documents that need to be signed, and then we submit everything to the court, and oftentimes that's when we're waiting. So we could oftentimes get everything ready and filed to the court within 4 to 6 weeks after a person's passed away, if not sooner. But then it sits at the court for 2 to 3 months because it goes on a pile, and then, you know, they chip away at the pile until you're up next. And that's, you know, it takes a while. Okay, so apartments. So somebody asked if somebody dies and has an apartment, can they get into the apartment? It depends what county you live in. In Manhattan, oftentimes, the apartment will be sealed, and it's a pain in the rear so that the executor cannot get access, or the administrator cannot get access to the apartment, especially if you've passed away in the apartment. And that really happens if you pass away in the apartment. It is sealed until your administrator or your executor has been appointed by the court. You could plan for the best, but there's no guarantee that it won't happen. I haven't really seen it happen in Westchester. It may have happened. I'm not aware of it. And it happens in surrounding boroughs, not as much. It seems like in Manhattan and sometimes Brooklyn, these apartments will get sealed. Especially if you've passed away in it. It's their rules. They'll seal it. Give somebody the keys, but sometimes they'll put tape over the apartments. If you didn't pass away in the apartment, oftentimes it won't get sealed. And you just want to make sure somebody has access to, like, somebody has the key or access to your apartment, because then if you go to the super or whoever to access, then they may say, no, I want to see your court papers. So if a will was made 15 years ago and it has been lost and no one recalls the contest, is this considered intestate by New York State? Probably yes. If you can't locate the original will, even if you knew what the contents were and you can't locate the original, it's presumed revoked under New York State law. So you want to, if that person's still living and has capacity, create a new will now. How do you appoint an executor without probate? You can't, is a short answer. So that's a good, because this is another common misconception with this probate process, because people come to me, will say, well, my mom appointed me the executor. The will says, it's right here. It says I'm named the executor, but the bank is telling me I can't access the accounts. You can't, because we have to go through the court process. So even though you're appointed executor under the will, or you're nominated, you're not officially appointed until you get, in New York, what's called letters testamentary. You have to get the court decree or the order officially appointing you, and you get what's called letters. And those letters are what you need for your official duty to be able to act. What's the amount of a small estate? $50,000. And what I mean by that, again, this is a New York State, and they just raised it from $30,000 to $50,000 a couple months ago. If you die with probate assets that need to be administered through the court, less than $50,000, it's a simplified proceeding. it's usually much faster and you could gain access, and you have to have specific information on those assets. Which reminds me, because every once in a while, this will happen to me really with small estates. Everybody who lives in New York State, when we get off this call, you should go to New York State, Google New York State unclaimed funds. Look to see if you actually have assets that have not been claimed by you. Sometimes they're just stock dividends. It could be a refund from a Con Ed bill. It could be just, it could be, and you don't really know how much until you submit the claim, but it's enough to tie up, for us. Oftentimes it costs more in legal fees for us to get access to that money than what the actually money's sitting there. But Google New York State unclaimed funds, search for your name, and see if you have money sitting there. I found money for my mother-in-law one time. Well, as attorneys, we always look for it in the state. So when somebody comes to us, we'll enter the decedent's name to see if there's assets there. So if someone is on Medicaid and has no more than $10,000, can a nursing home go against the heirs to claim any amounts due? Typically not. Now there's some exceptions, or if there was, and sometimes if there's a surviving spouse, yes. And sometimes, but usually if they don't have more than 10,000, we usually don't have to go through probate. If we go through probate though, if there is a reason to go through probate, New York State, and you're on Medicaid, New York State has the right to pursue recovery against your estate. However, another plug for a revocable trust, which wasn't my intention here for today's call, but you could see how sometimes these revocable trusts can benefit you. So New York State actually cannot recover Medicaid that was properly paid from revocable trusts upon somebody's death. Now, the revocable trust, it only works usually with houses because the assets in the revocable trust are counted as your assets. So if you don't meet the assets, so you have to have less than $15,000 in assets in order to qualify for Medicaid in New York. But if sometimes you have your house, and your house, you're living in your house and you're receiving Medicaid. And if your house is in a revocable trust, and this is under current law, it could change. They tried to change it a couple of years ago. But if your house is properly titled in a revocable trust, typically Medicaid cannot seek recovery against that if they did not put a lien. Sometimes they'll put a lien against your house during your lifetime, which is another, again, beyond today's purpose call, because we could probably have a whole half hour talking about that, and we're coming up against 1 o'clock. What does it mean that wills go through probate? I think I talked about that throughout this call, is that you have to complete a petition for probate. Actually, I didn't get into details like this, but you have to complete a petition for probate. Oftentimes you need a lawyer. You can do it without a lawyer, but you have to have some sophistication to know what paperwork needs to be done and completed, and who has to sign and who has to waive and consent. But there's this whole package of documents that has to be submitted to the court through probate, including a probate petition, the original will, a death certificate, consents or waivers from all the beneficiaries, and some other documents. Sometimes we have to submit a paid funeral bill. And then the court will review everything. And if there's no issues and we're not dealing with any minor beneficiaries or any beneficiaries who have incapacities or are disabled, then we usually could get through without having to have a court appearance. Like, no court appearance is required. And the court will issue a decree granting the probate of the will, that the will is valid. Probate means that you're proving the will. The will is valid, and then letters issue. So that's what that means. I hope I answered your question. Let's see if we got through everything. What if non-probate are 100? Right. I'm not going to get into Medicaid too much today. If the non-probate assets are $100,000, can Medicaid seek recovery? It depends on the particular situation. Sometimes no, sometimes yes. And that's probably because I'm up at 1 o'clock, and I appreciate everybody sticking on. Any other last questions? Thank you so much for joining. I hope that you got something out of this today. All right, thank you.